Okay, we are now broadcasting.
Okay. Good morning. My name is Jill Flessing, and I serve as the chair of the Addiction Counselor Advisory Committee of the Kansas Behavioral Sciences Regulatory Board. I ask that the members of the advisory committee respond to roll call to signify their presence at this open meeting that is being conducted remotely by conference call and other electronic medium. Jacqueline Lightcap.
Here.
Christina Boyd.
Present.
Lisa Carter. Jason Hess.
Here.
Shane Hudson.
Here.
Chad Jacobs. Mike James, which we spoke about. Charity Cosson. Dulcinea Rakestraw.
Here.
And Zenova Williams.
Present.
I note the following BSRB staff members are also present: David Fye and Leslie Allen. Next, David Fye will read a message concerning this meeting being held remotely.
Thank you, Jill. And also from the BSRB staff member, licensing specialist Sammy Barksdale is present as well. This is David Fye, Executive Director for the Behavioral Sciences Regulatory Board. Public comment allows the public to address the advisory committee about its concerns, but the Kansas Open Meeting Act, or KOMA, does not require the advisory committee to provide public comment or answer questions from individuals. Individuals requesting to provide public comment could contact the executive director prior to the meeting by sending an email to david.fye@ks.gov. There will be no public comment at this meeting, as no individuals have requested to provide public comment. Because we are conducting this public meeting remotely by conference call and other teleconference ability, I state for the record the following information. Public access to this meeting is being conducted by a medium of interactive communication that allows members of the public without cost to attend the meeting through the use of the conference call and on the board's YouTube channel. While the meeting is conducted remotely, the requirements of KOMA are not suspended. We will be conducting this meeting pursuant to the KOMA. On July 6, 2023, we sent notice of the advisory committee meeting to all individuals who had requested notice of advisory committee meetings. The notice was also posted on the board's website, ksbsrb.ks.gov. You may obtain a copy of the notice at that website. An agenda and other media material have been posted on the board's website and are available for review. You may also request a copy of the agenda specifically by sending an email to david.fye@ks.gov with a subject line request for the agenda, and it will be sent to you. The notice contains information for the conference call and YouTube channel that allow members of the public to attend the meeting free of charge. The notice also states that if we have any technical issues during the meeting, you may call the board office at 785-296-3240 or send an email to bsrb@ks.gov. A recording of the meeting will be available on the BSRB YouTube channel following the conclusion of the meeting by using the link to the meeting on the agenda. And the conference call line is active. I did check that before we started the Zoom call this morning, and no one is on the conference call, but I'll let you know if someone logs in. And also, while we were going through that introductory information, Lisa Carter has joined the meeting, so she is also in attendance as well.
Okay. This meeting is now called to order, and the advisory committee will begin its discussion of the first item on the agenda. The first item is agenda approval. I would ask if there are additions or corrections to the agenda, and if not. Sorry, did somebody say something?
No.
If not, I would ask for a motion to approve the agenda.
This is Jason. I'll move to approve the agenda.
And this is Dulcinea, and I'll second that.
Okay, the agenda has been approved. A motion has been made for approval and it has been seconded. The agenda has been approved.
And Jill, would you like to go ahead and take a vote since there was a motion and a second on that?
Sure. Any advice on how to do that?
Sure. You could just say all in favor, say aye, or you could say, is there any opposition to approving the agenda? Either one would be fine.
Okay, is there any opposition to approving the agenda?
No.
No. Okay, thank you. Now the agenda has been approved. David, would you like to speak to the third item on the agenda?
Sure, I'll go ahead and just kind of frame that item. So happy to announce that there are new members of the advisory committee for this meeting. And so first we have a new chair of the advisory committee. The governor has appointed Jill Flessing to be the new board member for addiction counseling. So we're welcoming her to the board, and also in her role as a board member for addiction counseling, she is the chair of the advisory committee. So I'll go ahead and turn it back over to you, Jill, if you want to go ahead and share a little information about yourself.
Thank you, David. I appreciate it. I appreciate this opportunity to serve the BSRB and the addiction counseling world. I don't know if you want to know a little bit about me. I have been a clinical social worker, clinical addictions counselor since 2007. I have worked in community mental health. I've worked in a safety net clinic in Lawrence, and now I work at Counseling and Psychological Services at KU with KU students. And I am likely going to defer to David a great deal in this meeting. This is all brand new to me, and I am in the learning process of how the committee process works, how the BSRB board process works. And I'm looking forward to working with you all moving forward into the future.
Well, that sounds great. And again, welcome to the advisory committee, and happy to help out. And I know that goes for Leslie Allen, the assistant director, as well. If we can make your transition to board membership and chair of advisory committee smooth, just go ahead and reach out with any questions.
Thank you.
Very nice to meet you.
Thank you.
And at the last meeting, I think actually this was an earlier meeting of the advisory committee this spring, there was a discussion on additions to the advisory committee. And at that time, the advisory committee recommended that Zenova Williams be added to the advisory committee. The advisory committee terms operate by fiscal year. And so for the state fiscal year, that begins on July 1st. So this would be the first meeting for new advisory committee member Zenova Williams. So Zenova, if you'd like to introduce yourself to the committee and share a little bit about your interest in serving on the advisory committee and maybe a little about your background, I think that would be helpful.
Okay. All right. Well, thank you for that. So my name is Dr. Zenova Williams, and so I'm an assistant professor at Washburn University. And so at that particular university, we have addictions counseling licenses at the associate's, bachelor's, and master's, and I'm also serving as the master's program director for our university, or for our program. I have been in the addictions field since probably my undergraduate days, and also serving families, couples, and things like that, all across the country. And so doing research as well. And so I'm from Mississippi. I don't know if I said that. And so I got most of my degrees from Mississippi, but my PhD I got at Kansas State University. And so I've been in the addictions field. I'm going to serve at University of Washington, St. Louis, University of Pittsburgh in Pennsylvania, UCLA, University of Southern Mississippi, Jackson State University, St. Mary's in Colorado, and also just several other addictions treatment facilities, so nicotine, alcohol, sex addiction, and other kind of addictions and process addictions throughout the country. And so, yeah, I have a long history, or I guess long, about 15 years or so of that, and also a passion for it, and also teaching about it. So, yeah.
Well, again, welcome to the advisory committee, and look forward to working with you. And the same offer that I extended to the chair of the advisory committee, I'll extend to you as well. If you have any questions about anything, feel free to reach out to Leslie or myself, and we're happy to help with your onboarding process.
Nice to meet you. Welcome.
The next item on the agenda is review and approval of minutes from the previous meeting. I was not present. David sent out the minutes this week. You've all had a chance to review it. I wonder if there are any corrections or additions to the minutes of the previous meeting. Okay. there are no corrections or additions, I would ask for a motion to approve the minutes from the previous meeting.
I'll move to approve.
I'll second.
Okay. Is there any opposition to approving the minutes from the previous meeting?
No.
Minutes from the previous meeting on June 2nd, 2023 have been approved. And I'll just hand it over to David.
Okay, thanks, Jill. So at each full board meeting and also at each advisory committee meeting, I present an executive director report, which provides some updates on items for operations here at the BSRB office, and also some items from the most recent board meeting. And then if there's any other notable items, such as from national associations or from any legislative activity, I try to give some updates on those as well. So I'll cover a few of those different items. It has been busy with the state fiscal year turning over between the end of state fiscal year 2023 and now we are in state fiscal year 2024. There's a few annual responsibilities that we have. First, there is an overall auditing system that the state uses. And so as part of that, every state agency has to complete and submit about 15 different annual reports. And so I had worked on those last month and submitted those on behalf of the BSRB. And so some of those involved some small amount of federal funding that the BSRB received. As you might recall, last year they had made some funding available for agencies to modernize equipment. And I had submitted two essentially grant proposals, one to buy a camera for the boardroom to be able to do hybrid meetings more effectively, and then the other to replace a projector. And so we did get approval for a little over $2,000 to complete both of those projects. Those have been completed. I went ahead and filled out the appropriate forms for that. And so now that has all been completed. So, but those annual reports have been submitted. Also, as part of an annual responsibility, the BSRB, the governor's office actually asked each agency to submit a 3-year IT plan. And so these are items that are short-term goals or long-term goals for each agency. And they ask agencies to provide updates on successes or items they're still targeting. So just as a kind of a little bit of a heads up, last year, some of our short-term goals were to replace some of our outdated technology, or provide better equipment for use for hybrid meetings. And so happy to report that the hybrid meeting functionality has greatly improved. So that item has been crossed off the list. We are still in the process of converting some of our existing desktop computers to laptop computers through the state's Desktop as a Service program. We started that as sort of a phase-in approach 3 years ago, and we did a few the first year and then some last year, and this year will be the remainder of the staff members. And so we'll all be on a cycle with the state, so that way we don't all come up at the same time. But having better technology should help the overall process. So happy to move forward on that item as well. Additionally, we are in the process of moving towards having electronic records here at the BSRB office. There's a number of reasons for that, but it would help out with some of our spacing issues, but it would also make staff more efficient to be able to access those records electronically versus paper. So that's one of our long-term goals. We have put some recent items in place to make that process a little more seamless, but we're still working on that. One of the items that I took care of last month, we have a document retention schedule with the state, and every agency does, but ours previously had said that all agencies would, or the BSRB would retain records for licensees here in the office until the license expired plus 10 years, and then they would be transferred to an archive for storage. And so in wanting to convert our records to digital, we sought permission from the State Records Review Board to see if we could change that retention schedule to expiration plus 2 years and then transfer the records to the archive. The thought being that if we could do that, we would have a lot fewer records that would need to be scanned when we do convert to digital. So they approved that request. I testified in front of that committee, and then they voted to approve it. And so we have been in the process, essentially the last month, of trying to collect 8 years of records that we can now move to the Historical Society. And so when I say that we keep them here on site and then we transfer them, we don't destroy those records. The Historical Society has indicated that those records have a value. And so essentially, we will keep them on site for now till expiration plus 2 years, and then transfer them to Historical Society. And if we ever need to access those records again, we can make a request to the Historical Society. But in the meanwhile, our staff has been working on all of those records. And so we are hoping to have about 30 boxes of records picked up sometime in the near future. Some of the other items that we have been working on in terms of annual responsibilities, there was a bill that passed a couple of years ago. It was a modification to an existing statute that dealt with licensure of military members, but the significant changes happened in that 2021 law. That was House Bill 2066. Some of the items that were changed in that bill, it created a expedited review time for military members and military spouses, and then it established a review time for non-military members and military spouses that do reside in Kansas or intend to reside in Kansas for reciprocity. And so it also provided an alternate pathway for reciprocity compared to the existing statute. And so one of the items in combination with that is an annual report that each agency that is affected by that would have to provide to Legislative Research Department. And so that report is due on September 1st. So I've been working with the Board of Healing Arts, which hosts our licensing database, to pull those numbers and be able to provide that data. And so I expect that providing that report by September 1st, I'll be able to give an update to the full board at the next full board meeting on September 11th to let them know how we did in terms of those processing times for the military members, military spouses, and other individuals that are required to have reporting under that change in law. In terms of some other items that we were working on in terms of operations, this past legislative session, there was a significant bill that passed that affects the BSRB. It was 2023 sub for Senate Bill 131. And last year, the board and the advisory committees did a lot of work on different recommendations to request in bill form from the legislature. And when the session started, there was a significant bill, a large bill that included many different items for the BSRB. That bill went in front of the House and Senate Health Committees. There were some changes to it, but the final version was passed as Senate Bill 131. And since the passage of that bill, the agency, the BSRB, has been working to try to implement as many of those processes as possible. And so the bill was effective as of July 1st. And so that was the first date that we could begin anything related to the bill. And so we did go ahead and move forward on some of those things we can move forward on immediately, such as for a lot of the professions, the length of time for new temporary licenses that we could issue changed from 1 year to 2 years. So as of July 1st, any new temporary license for some of those professions we could now make for 2 years. The length of time for certain reciprocity applicants was reduced from about 48 months down to 12 months to make it kind of more consistent with the changes in that military reciprocity bill that passed in 2021. There was also creation of several new license types. The student addiction counselor license type that this advisory committee had proposed a model for, that was approved in that bill. For some of those changes that happened in the bill, if it's a new license type, there is an associated fee. And the bill itself establishes the cap, and the language says you can charge no more than X amount of dollars for that fee. But then to be able to implement that, we would need authority in the regulations to set the specific amount for the fee. And so after the bill passed and we did have authority, we put in a temporary regulation to get authority to put in the regulations for the fee changes. And then we followed that with a permanent regulation. And so that's kind of where we're at in the process right now. Just last week, we launched a few more of the items. So the student addiction counselor applications are posted on the website. Those are active now. The social work new license type that is for applicants that are in candidacy for accreditation, their programs are. Those individuals we're now able to evaluate for that new license type. And there are a number of other changes that we posted about. There's a new type of license called a community-based license, and those forms are now available on the website as well. So I think we're very close to having all items implemented, which has been a tremendous amount of work. And I have to give a lot of credit to Leslie Allen, the Assistant Director and Licensing Manager for the BSRB. She has done a tremendous amount of work, and I've tried to help out with that process too, in terms of other responsibilities, but I know she's had a number of conversations with our host of our licensing system. You know, when we're trying to implement these things, there's a lot of technical work behind the scenes. To actually issue the license, there has to be testing to be able to make sure that we have the mailings correct and the official issuance of those things. And then there's certain requirements in terms of publicizing proposed changes to regulations and the committees. And so it's really a significant process, but really excited about all the changes we've put together already. And as we can kind of move forward and make more people aware of some of these changes, I think it'll be really beneficial. Additionally, in all these new responsibilities that we have because of the passage of that bill, the legislature did authorize us to hire 2 new licensing specialists. And so we have been in the process of writing up position descriptions, interviewing applicants for those positions, and happy to announce that we have selected 2 individuals to hold those positions. They were already on staff with the BSRB at different positions, and they wanted to challenge themselves to more responsibilities. So really excited about seeing staff members grow and take on additional responsibilities. But what that meant is that we needed to open up those positions to interview and advertise for that as well. So we are getting close to the end of that process. We are bringing another permanent employee on board as of this Monday. And then next week, we'll be interviewing applicants for a clerical position. So really excited about that. And then once that all stabilizes, we'll be able to move forward and be able to review licenses effectively in an efficient time frame. Additionally, one other item in terms of annual responsibilities, every state agency must submit a budget to the state of Kansas by September 15th. And so we will be working on that and working to submit that by that September 15th date. Last year, the legislature did approve a revised budget for fiscal year 2023, and then a budget request for every agency that's a biennial like us that operates by fee funds. So they approved a budget for fiscal year 2024 and 2025. So this year, the budget request will be any kind of modifications to fiscal year 2024 and 2025. So I will be working with some of our vendors to come up with new cost estimates and new revenue estimates, and then I'll be submitting those on the agency's behalf. Shifting to some updates from the last board meeting, the board met on July 10th, 2023. At the time, there were 2 new board members who joined the board. David Stevens is a new public member for the board. He is taking the position previously held by John Norton. And then also Linda Heitzman Powell is a new board member for licensed psychology. That's a position previously held by Rick Steele. And one of the notable things about Linda, Linda had previously served on the Behavior Analyst Advisory Committee. Even though she is appointed by the governor as a licensed psychologist, she holds both licenses, licensed psychology and behavior analysis. And you may recall last year, one of the board's recommendations in legislation was to request new legislation to hire or to expand the board by having a 13th board member, one for behavior analysis. We are a composite board and we oversee 7 professions, but currently in statute, it does not identify a behavior analyst to serve as a board member. And so without that being in statute, the question had been, well, could a behavior analyst serve on the board? And officially, the governor does not have authority to appoint someone specifically for the behavior analyst profession. However, we always said if a board member held that license, that would mean that a behavior analyst would be on the board. And so with Linda holding both licenses and being appointed for licensed psychology, officially she is the board member for licensed psychology, but she also does provide some perspective from the behavior analyst profession as well. So that's a helpful new item to have on the board. And then Deb Stidham was the previous board member for addiction counseling. And so we knew that there would be an upcoming appointment for her position on the board. And so really excited to have Jill Flessing with us as the new board member for addiction counseling. So in terms of some other items from that board meeting, we had discussed some proposed changes to regulations. Those were the items I discussed a little bit earlier that dealt with the fees primarily associated with the passage of that bill. Those proposed changes to regulations are currently in a time for public comment. And so essentially during the process, when you try to change regulations, you put them out for public comment for about 60 days. And when that happens, you publish notice in the Secretary of State's publication, the Kansas Register. And so anyone can submit written comments on the proposed changes to regulations. Additionally, we will have an open meeting at the BSRB office, and that will be on October 3rd, 2023 from 10 a.m. until 11 a.m. And so that will be for anyone who wishes to come and provide more public comment to us on the proposed changes to regulations, that is the time for them to do so. And then basically after that public meeting, we would take any public comment on the proposed changes, give that to the board, and then the board would need to formally choose to adopt or make other changes to the regulations by a roll call vote. And if they did adopt those, then we would publish the permanent regulations in the Kansas Register, and they would be effective, I believe, about 10 days after they're published. So moving forward in that process, we also have a separate set of regulations that we had submitted earlier this year, and they had been reviewed and approved by the Department of Administration, and they are currently being reviewed by the Attorney General's office. And we recently spoke with representatives of their office on those other changes to regulations, and we're going to be meeting with them next week to discuss edits and possible changes to those. Some of those have to do with, for your profession, recognizing a national accrediting body for addiction counseling as a way to expedite the license process for some of those individuals who had received their education from a program that is accredited. Most of the professions under the BSRB recognize a national accrediting body, but currently two do not. That is master's level psychology and addiction counseling. So once that regulation would go into effect, if someone had received their education from that program, we would be able to move them through the process for licensure a lot more quickly. And for some of the other professions, and I believe your profession as well, one of the other changes as part of that set was individuals who had attended a program that was either not accredited by a national accrediting body or did not meet the standards for that accreditation process would be able to meet alternate requirements. And one of those that has been an issue at times has been a requirement that certain coursework needed to be received while the applicant was physically present. And that set of regulations addresses that topic for 4 of the professions and would allow that to be substituted either physically present at the school or face-to-face by screen. So we're looking forward to having those changes go into effect as well. That will affect some applicants for licensure and should open things up a little bit more in terms of being able to license more individuals. So we will keep you updated as far as that goes. In terms of some other updates, we are getting ready for some of the National Association meetings. I will be attending a National Association meeting for Marriage and Family Therapy with the board chair at the end of next month. And then I will be attending a National Association meeting for the psychology profession at the end of that week as well. And then at the beginning of November, I'll be attending the National Association meeting for the social work profession. In terms of just a couple more items, the board has recently had some conversations about putting out an RFP to create an impaired provider program. Some other professions in Kansas and other states utilize a program as an alternative to certain disciplinary remedies if there's a violation, but there's also a finding of a practitioner who's struggling with mental health concerns or substance use, and so it is an available tool. Other states have a broader program that allows licensees to be able to seek support from that type of a program. So the board is interested in putting in an RFP and seeing what services might be available for something like that. And then also the board is in discussions right now in terms of creating a specific expedited application review process. The bill that passed this past session, language was added to that bill for the board to create such a process in rules and regulations, but there's really not a duplicate type system in any other state that I'm aware of to model it after. The board has had some good discussions about how they could develop an expedited application review process for certain types of applicants. And so at the next board meeting, the board will be reviewing some language on that item. And then the board seeks to have an offsite planning meeting every year. It's an all-day meeting where the board can talk about their legislative agenda or other items that really recall for in-depth discussion. The board is going to be having that offsite planning meeting on Monday, October 23rd. It will be from 9 a.m. until 4 p.m. and it will be in Wichita. And we will have more information posted on the BSRB website. And even though that meeting is off-site, it is still an open meeting. So if there's any individuals who wish to attend that meeting, feel free to reach out to us. We can provide more information, but that meeting will be open. And so happy to have the board come together in person and meet together and work on those items. And then just in terms of a few other updates, in terms of some legislative activity, I mentioned that there's a committee for the legislature that agencies go before when they're submitting rules and regulation changes. That's called the Joint Committee on Administrative Rules and Regulations. I appeared before that committee this past week and talked about the proposed fee changes for the BSRB. Additionally, there was a special committee that dealt with mental health And that committee met on Wednesday, August 23rd and Thursday, August 24th at the Capitol. Some of the topics they discussed in those meetings were mental health intervention teams, federally qualified health centers, and certified community behavioral health clinics. There was a roundtable discussion for stakeholders on the first day. And on the second day, there were some updates and presentations on the 988 National Suicide Prevention Hotline, youth suicide prevention research, telehealth presentations, and agency updates from the 2020 Special Committee on Mental Health Modernization and Reform. And so as a reminder, the Kansas legislature also has a YouTube channel. Those meetings are broadcast live, and then they're available to review. So those were full day meetings, but if you are interested, those videos are available to watch. That Special Committee on Mental Health was approved for a third day to meet this interim. At this point, I am uncertain if they will meet for their third day or if some of those topics will just carry over to the CanCare Oversight Committee, which meets quarterly. So with that, I will go ahead and end my report and see if there's any questions. And if there's no questions, then I think we could go ahead and move to the next item. Unless, Jill, do you have anything further on any of those items? Okay.
No, I don't. And I will defer back to you as the training for board members and advisory committee is the next item on the agenda.
Okay, great. Well, as you can tell, we've been pretty busy with different items here at the office, but we'll keep you informed as those items do work their way through the system and we have changes. And just as one more reminder, there's a lot of good information on the BSRB website. We try to post announcements. One of the items I didn't talk about is that a lot of the professions saw some fee decreases as of July 1st. The temporary licenses had ranged different amounts for the different professions. And earlier this year in January, the board voted to decrease the amount for temporary licenses so that each of the temporary licenses would be $50. And so the amount of decrease changed by profession, but it kind of made those all a little bit more uniform. And so we were able to start implementing that change as of July 1st. So now I'm going to shift and go through a training. So this training is a yearly training that each of the advisory committee receives. If you are new to the advisory committee or new to the board, I think it's especially helpful, but for members who've been on the committee before, I think it's a nice reminder of certain things. As a state agency, we are required to do certain things by law, but also there are different levels of responsibility. For example, we'll talk about this during the presentation, but there is statute or law, and then there are regulations, and then there's also policies, and it's helpful to kind of know the hierarchy of those and kind of understand your role as a board member or as an advisory committee member. And also I'm going to share a little bit of broader information about the BSRB as well that should help put some of this in context as well. So I'll share my screen here. Okay, so you should be seeing the PowerPoint presentation. This is the training for board members for this year. Let's start with the mission of the agency. So the mission of the BSRB, in accordance with the intent of the Kansas legislature, is to protect and serve the consumers of services offered by BSRB licensees through the issuance of licenses, resolution of complaints, and the creation of appropriate regulations, accomplished through efficiency, fairness, and respect to all those involved. Some of the history of the BSRB. The agency was created in 1980 by the Kansas legislature. It combined the existing Board of Psychology Examiners and the Social Work Examiners Board. And then over the years, the BSRB jurisdiction has expanded to include the licensure of professional counselors, master's level psychologists, marriage and family therapists, addiction counselors, and most recently, behavior analysts. Rather than have a separate board for psychologists, social workers, professional counselors, etc., there is one board composed of professional members and public members. This combination of individuals on one board is called a composite board. And by utilizing a composite board model, the agency saves a significant amount of operational expenses by sharing resources and utilizing the licensing and investigative staff for similar subject areas. One way to understand the role of the BSRB is to differentiate it from an association. A regulatory board exists to protect consumers. It is created by the legislature and it is governed by statute. whereas an association exists to enhance the profession and is often created by members of that profession. A little bit about the agency. The BSRB employs 10 staff members. We are soon to move that to 12, but at the moment we have 10, including myself, Leslie Allen, Assistant Director and Licensing Manager. We also have licensing specialists, investigators, and clerical employees. We are what is known as a fee-funded agency. So the BSRB does not receive funding from the State General Fund, but by statute, we actually give money back. We contribute 10% of all the revenue we receive, up to $100,000 per year, back to the state of Kansas, and that goes into operations. The agency revenue is primarily derived from license fees, and the annual budget for the agency is about $1.1 million. As a small agency, the BSRB contracts with and has agreements with many other agencies and other entities. All board members are appointed by the governor to serve a 4-year term and may be reappointed for a second term, allowing service on the board for a maximum of 8 consecutive years. The board is composed of the following individuals: 2 licensed psychologists or PhD level psychologists, 2 social workers, a marriage and family therapist, a professional counselor, an addiction counselor, a master's level psychologist, and then 4 public members. There are 2 basic functions of BSRB: licensing and investigation of complaints or discipline. In terms of licensees regulated by the BSRB, as of the last full board meeting and the report that we ran at that time, there are about 15,155 active permanent licenses under the agency, and those are in the 7 professions which I referenced previously. In terms of the specific license types, every full board meeting, I provide a report to the board and I break it out by license type within those professions. So currently, about 55 to 60% of all licensees are social workers. The largest group within the social work license profession is the master's level social work. We have over 4,000 master's level social workers. And then we also have about 2,900 clinical level social workers. And then there's other professions that have the numbers reflected here as well. In terms of new licenses, in fiscal year 2023 that just ended, the BSRB issued 1,586 permanent licenses, 433 temporary licenses, and 66 out-of-state temporary permits. Of the 1,586 permanent licenses issued by the board, 1,124 were initial licenses, and 462 were through reciprocity, which is individuals who are licensed in another state or jurisdiction who are applying for licensure in Kansas. We are still pulling some of our numbers, such as the totals for renewals and audits, but in the for context, the year before, in fiscal year 2022, the BSRB processed 6,214 license renewals, and as part of the license renewal process, 10% of all applicants are audited to ensure they have met the continuing education requirements. In FY 2022, the BSRB audited 625 individuals. You may be wondering why that number does not match 10% directly. It's because based on past disciplinary actions, there are a handful of individuals who have an automatic audit based on past conduct. Since July 2015, the number of permanent licensees has increased by 24.7%, from 12,152 to 15,155. Just for context, over that period of time, the rate of population growth in the state of Kansas is somewhere between 1% and 2%. So during that 8-year stretch, we have seen a 24.7% growth in total number of licensees, even though the population of Kansas has grown a lot slower. The professions with the largest increases during that time are professional counseling, social work, and also behavior analysis. We've talked about the licensing side of the agency. We also have a responsibility to oversee investigation and discipline. As a public protection agency, the BSRB investigates complaints against practitioners under the authority of the board. The agency has administrative authority over practitioners, but this process does not take the place of criminal proceedings or civil proceedings. So we do receive complaints against practitioners, but at times, one of the parts of our role is to make sure that individuals know that we are not a substitute for the police or the other legal authorities. So if we get a complaint that appears much more of a legal issue, we always make sure the individual filing the complaint knows if you believe that criminal conduct has been committed, we recommend that you reach out to law enforcement. Or sometimes individuals submit a complaint to us and they want to be a party to the transaction. They want to go after the person for damages, and that's not the role that we play. If they want to proceed in a civil transaction against the person, that's separate from our administrative authority. Once someone files a complaint, at that point, when we review and investigate it, it really is the state of Kansas against that person, based on what we have reviewed. And so while the person may submit the complaint, once we have received it, it's really us as the BSRB acting on behalf of the state and that person under the scope of their license as a professional to practice under the BSRB. In FY 2023, the BSRB received 200 complaints or reports of alleged violation against practitioners. And for comparison, practitioners received 205 complaints last year, 132 complaints in FY 2021, 199 complaints in FY 20, and 201 complaints in FY 2019. And if you're wondering why complaints went down so much in FY 2021, I can't say definitively why that occurred, except that was during some of the initial stages of the pandemic. So it is possible that some individuals were not able to receive services because of the transition. Other individuals may have shifted to telehealth, and this was their first experience with telehealth. They may not have been aware of what the appropriate standards were, or may have just been happy to be able to receive some services in general, even if it was an unconventional way. What I can tell you is that the decrease that we saw that year is consistent with what other states saw in terms of a decrease in the complaints. And similar to what we saw, the rise of complaints went up to the pre-pandemic levels after that first year. Other states have also seen it return back to that level as well. So it was an unusual dip, but it was not an unusual dip compared to other states and what they experienced as well. Complaints are reviewed when they are received, and we determine whether the BSRB has jurisdiction over the issue and whether the matter involves a potential violation of the statutes and regulations for the profession. Complaints / RAVs are reviewed by a subset of the board known as the Complaint Review Committee. And just one thing as far as jurisdiction, the two main things that we look at sometimes under jurisdiction. So with the BSRB, we do have 7 professions that we regulate, but sometimes there is some confusion from the public, especially when it comes to professions like psychiatrists. I know some people use the term psychologist and psychiatrist interchangeably, but psychiatrists have a medical degree, and so they're actually licensed by the Board of Healing Arts. And then there also can be some confusion on jurisdiction for individuals that practice in a city that's kind of in a border city between 2 states. For example, Kansas City, Missouri. There could be some confusion where they believe the person may be a Kansas licensee when actually they're a Missouri licensee. So occasionally we do get those, and then we basically forward them to the other jurisdiction to investigate or resolve. And then also there sometimes is a matter where someone is unhappy about something that their therapist or someone that they receive treatment from has done, but even if everything was true, that may not have been a violation of the statute or regulation. This is not a general process where we accept all complaints against persons for any reason. The reason why we call them reports of alleged violation is because either have to be a violation of the statute or regulation. But even though it made someone unhappy, that doesn't necessarily mean that it's something that we have jurisdiction over. So sometimes there are cases that are dismissed for lack of jurisdiction for that reason. Some of the common violations that we see include falsifying continuing education requirements. This can occur during an audit, also practicing without a license or practicing with an expired license, having a dual relationship or a conflict of interest, making sexual advances towards or engaging in physical intimacy with any client, refusing to report termination or suspension back to the BSRB that occurred for certain reasons, confidentiality violations, practice issues such as performing services inconsistent with one's education or accepted professional standards. And now shifting from, we talked about licensing, we talked about discipline. One of the other functions the agency performs is outreach. So myself as the executive director and Leslie as the assistant director and licensing manager, we speak to many different groups of students to provide information on licensing and disciplinary matters. We hope to provide a proactive approach to assist individuals before they become licensed. We do think it's best for individuals when they enter the licensing process, they have a general idea of what they can expect and have the opportunity to get questions answered. But we also want to make sure that individuals are aware of some of the common ways in which individuals struggle with professional conduct. And so We try to speak to many different groups, and in FY 2022, we did present presentations to about 18 different groups. And then I'll talk about the BSRB YouTube channel. That is one of the nice tools that we have as well. So back during the earlier stages of the pandemic, we launched a YouTube channel on behalf of the agency back in January of 2021. To this time, we have broadcast live or uploaded afterwards about 124 board meetings or advisory committee meetings, and those have been streamed live or uploaded. They have been viewed a total or over now 4,300 times. And so prior to us using the YouTube channel, I believe in terms of the number of in-person attendees we had at board meetings and advisory committee meetings combined over the course of a year, I heard that number was sometimes between 10 to 15 and sometimes lower. But being able to broadcast the meetings and make them more accessible has been a huge success. And it has led to some additional questions, more individuals requesting to speak to different committees or forward information to committees. So really happy about the progress of this. It continues to be helpful. And so looking forward to continuing to make more information available to the public through the use of that YouTube channel. Also on our website, we make it a point to provide good, helpful information at ksbsrb.ks.gov. Some of the features on the website are we have a portal for individuals to renew their licenses. We have copies of forms and other applicant material. Statutes and regulations are linked on the website. Proposed changes to the statutes and regulations. We also have complaints or report of alleged violation forms, disciplinary orders against practitioners when those matters have been made public disciplinary orders. And then we have information on board and advisory committee meetings. And then now we're going to transition here, and I should have mentioned this at the very beginning. These slides that you see, this PowerPoint is very large, so it was not sent out ahead of time, but we're going to walk through it at this meeting. And if you do want to go back through any of these slides, they are posted on the BSRB website with the materials for the meeting. There's a separate page for each of the advisory committees, and it's broken out by the meetings and the materials that are helpful for those meetings. So you can go to that and navigate to this PDF and then kind of track through this. But in your materials, I did provide 3 different documents. One was titled Expectations of Board Members. And so we'll start with that document in terms of expectations. This was a policy that was adopted by the board over 10 years ago. I think they wanted to outline a little bit clearer the expectations that the board wanted to put on themselves as members, and then provide some general direction of some policies, and then also some values they wanted to enforce. So this is posted on the BSRB website under the policies section of the website. And the document says the authority, insofar as the expectations for board members conflicts with or limits any federal or state statute or regulation, the statute or regulation controls. So while this is a helpful document, if there is any conflict with the expectations of board members document versus the law is going to win. The same with regulation, but it is helpful as sort of a third tier of authority. In terms of the guiding principles, persons in Kansas shall expect that licensed mental health providers are qualified, competent, and professional, and persons regulated by the BSRB shall expect equitable and fair treatment in relation to licensing activities, disciplinary processes, and administrative regulation. The BSRB shall provide all services in a manner that is timely, cost-efficient, courteous, and competent, and the BSRB shall be guided and led by ethical principles, clear policies, progressive thinking, and strategic decision-making. The BSRB shall respect the dignity and worth of all individuals. In terms of services, BSRB should process license applications and license renewals in a timely manner, take disciplinary action when appropriate, provide timely information to the public, and maintain rules and regulations and statutes. In terms of a code of conduct, the board wanted to stress first integrity. A board member of the BSRB should have no criminal or professional misconduct record, nor commit acts that would lead to investigations or complaints. A board member of the BSRB possesses sound moral principles, for example, is upright, honest, and sincere. A board member of the BSRB has courage of convictions to withstand pressures to be swayed from the public protection agenda. A board member of the BSRB should be honest about personal agendas and leave them outside of the boardroom. A board member of the BSRB should reveal any actual or perceived conflicts of interest and appropriately recuse themselves from decisions or actions in those areas of interest. A board member of the BSRB should not represent their personal opinion as that of the board. A board member of the BSRB should be limited to 1 unexcused absence per year. And then in terms of conflicts of interest, a board member of the BSRB should guard against conflicts of interest. To ensure compliance, common components of conflicts of interest policies include, but are not limited to, some or all of the following. A board member of the BSRB should have no personal financial benefit as a result of service to the board, except sustenance and mileage. A board member of the BSRB who may have a conflict of interest according to stated criteria should refrain from voting on the matter. A board member of the BSRB should disclose any relationship with any other agency or individual involved with the BSRB and be excluded from matters involving such conflict. A board member of the BSRB serving as a part of any organization working in any way with the BSRB should inform the board chair. And a board member of the BSRB should not accept any gifts or promotional items received as part of the affiliation with the agency for personal use. A board member of the BSRB should not use the agency's name or agency information for personal gain. I do want to circle back around to item D. A board member of the BSRB serving as a part of an organization working in any way with the BSRB should inform the board chair. So I know that in the mental health area, there are a lot of different associations, and it's not uncommon for board members or advisory committee members to be a member of an advisory committee or on the board, and also be a member of different groups or associations. And so what this really is going towards is whether that would pose a conflict. If you are, and we'll talk about this a little bit later, but if you're higher up and you don't believe that you would be able to separate your work with an organization or entity that's working with the BSRB, that's something to keep in mind in terms of a conflict of interest. In terms of confidentiality, board discussion involving any of the following matters shall remain confidential unless the board expressly agrees to the contrary. 1, any discussion that occurs during executive session, and 2, any discussion concerning actual or potential litigation. And we'll talk a little bit more about what an executive session is, but that's much more likely to occur at a board meeting than an advisory committee meeting. And if we ever do go into executive session, we will make it very clear that it will be something in executive session. Executive session is something where there has to be a formal vote. To enter into executive session, what would happen is that the meeting would continue, but we would go into a separate area, likely over a conference call away from the main stream. And then those matters would be resolved in a confidential setting. But we'll talk a little bit more about executive sessions, but if something is said in executive session, it is expected to remain confidential. The expectations of the board members document talks a little bit about the board chair authority. The chair of the board shall preside at all meetings, appoint members to the advisory committee, appoint members to the complaint review committee, and appoint members to other ad hoc committees. The vice chair shall discharge the duties of the chair in his or her death, disability, resignation, or death. And in the event that the executive director is unable to perform the duties of the office of executive director, the BSRB may request an interim director. If the BSRB is unable to meet immediately, the board chair will seek an interim director until the board can meet. The expectations of board members document includes some information about the relationship of the executive director to the board. So it does say the executive director will communicate any personnel matters that should be addressed by the board to the chair of the board. The chair of the board will present these board-related issues to the board, and the executive director will communicate to the staff the board wishes, intentions, policies, etc. Delegation to the executive director. The executive director shall be the administrative head of the organization, serving at all times under the board. The executive director will be responsible for implementing and executing the policies and activities approved by the board. He shall assist in the development of the overall program and shall recommend policies and activities for consideration by the board. The executive director shall have sole authority to employ, eliminate, and fix the duties and salaries of other employees or independent contractors of the organization, subject to policies, regulations, limitations approved by the state of Kansas. And just to let you know, while I do oversee the interview process and choose which individuals to recommend to be hired by the agency, the governor's office does have oversight. And so any individuals that we wish to hire to a permanent position and the amount that we wish to pay those individuals, that has to be submitted and approved by the governor's office. So there is a check in place for that process. In terms of the expectations for the executive director shall keep the board advised of BSRB activities by issuing a report to the board at each full board meeting, which summarizes pertinent information. The executive director shall prepare the agenda for board meetings in consultation with the board chair. The executive director shall prepare the agenda in consultation with the board chair for the annual board retreat. which shall allow for issues before the board that need in-depth consideration. To monitor the executive director's performance, the board shall, when necessary, utilize executive session to discuss issues concerning the executive director. The board shall also formally evaluate the performance of the executive director each calendar year and on an annual basis thereafter, with emphasis on whether set outcomes are attained. And I think it's a really good process. Department of Administration asks us to do annual evaluations for all employees in the state of Kansas. So I do that with my staff members, and I'm happy that the board does a formal evaluation process for me each year as well. In terms of the next document in your packet, you have a short document. It's about 2 pages called the Advisory Committee Policy. And so we'll talk a little bit about that document now. So to assist the work of the board utilizes 7 standing advisory committees, 1 for each of the 7 professions regulated by the board. The advisory committee policy is posted on the board's website. And currently, there's about 53 individuals, and these are non-board members, who volunteer their time to serve on these advisory committees for the board. In terms of the purpose, the advisory committee, as the creation of the board, has the purpose of supporting the board in carrying out its mission to protect the public. Members serve at the pleasure of the board. Actions pertaining to informing, licensing, and disciplining of those persons regulated by the board are the method for accomplishing this mission. Also, the process for the advisory committee. An advisory committee fulfills its purpose by addressing issues referred to it by the board through the advisory committee chair or the executive director. A committee may suggest issues it believes the board should consider by referring those through the chair of the advisory committee. When an issue is forwarded from the advisory committee back to the board has 3 options. 1, agree the issue needs to be addressed at the board level. 2, agree the issue should be addressed and refer the matter to the appropriate person or committee for additional information, review, or analysis, which will then be brought back to the board. Or 3, decide to not address the issue. In terms of the structure of the advisory committees, chairs of the advisory committees will be members of the board. If the profession is represented on the board, the chair of the advisory committee will be a board member licensed in the discipline of the committee and appointed by the governor to represent that discipline on the board. Any other board members appointed by the governor to represent that discipline on the board will serve as a member of that advisory committee. A public member of the board will also be a member. There will be a minimum of 3 and a maximum of 10 additional members appointed. The executive director will be a non-voting ex officio member. The assistant director or licensing manager is encouraged to attend, and legal counsel representing the board should attend meetings when their attendance is requested. Terms of the advisory committee members will be 2 years, and they can be appointed by the chair of the BSRB to serve up to 4 terms, so 8 years total. Appointments to the committee should be staggered to avoid having too many members of the advisory committee reach their maximum length of service at the same time. This next language I have bolded and italicized because I think it is really helpful in terms of understanding your role as an advisory committee member. The structure of the advisory committee states that the policies and procedures under which the BSRB board members are expected to operate will apply also to the advisory committee members. And that language has never fully been fleshed out in terms of the extent of what it means. However, I think one thing to take from this is that we covered the expectations of board members document. And you may have been wondering, why are we going through this in so much detail if it's an advisory committee meeting? Well, this language here that the policies and procedures under which the BSRB board members are expected to operate will apply to the advisory committee. What I would take from that is the language that talks about confidentiality and sort of those values that are in that document. I would also strive for those as a member of the advisory committee. And then also there's a note here that says the chair of the BSRB can remove members from the advisory committee. In terms of the selection of advisory committee members, members for the committee may be nominated by anyone, including the public, committee members, members of the professional organization, either the discipline's own or others, or through self-nomination. In reviewing nominations, the committee should work to ensure there is diverse representation, including but not limited to geographic setting, gender, culture, and ethnicity. Members should provide representation of the levels of licensing for that discipline, and those members should be selected from among public and private practitioners and educators. The committee as a whole discusses nominations and reaches recommendations on new members. The nominee's resume, a letter stating the reasons why he or she desires to be appointed, and a copy of the board's mission and goals to which the nominee has indicated agreement are to be reviewed. The chair of the committee will submit the committee's recommendation for new members to the BSRB board chair. The chair of the board will review the recommendations and may request input before making a decision, which will be announced at a board meeting. After the appointment has been approved, the executive director will inform the advisory committee appointee by letter or email. The executive director may assist the new member by providing information which will help orient the member to the board and advisory committee's role and function. And now we're going to shift to a third document in your packet. And this is a short 2-page document that we developed just a couple of years ago to help individuals from the public understand a little bit more the role of the advisory committee. So it's an official policy posted on the BSRB website, and it clarifies that public comment is not entitled to individuals, but could be approved. It outlines the processes that should be followed during comments to the board or advisory committees and topics relevant for public comments to the boards or advisory committees. It also clarifies the board wants to receive valid complaints against practitioners and provides information on how those complaints are to be submitted. But it informs potential attendees that certain matters concerning specific licensees will be considered in a closed, standardized process, and that is to ensure fairness to members of the public and to licensees. And now I'm going to transition to some broad information that I think is helpful for individuals in licensing activities. So this would be information for members of boards of different professions, but it does help explain some of the responsibilities of board membership and also some of the laws that we're required to follow. And so we'll kind of walk through this document as well. The state of Kansas regulates many professions. Each of these professions is regulated by a licensing board or commission that was created by the Kansas legislature for the purpose of ensuring that licensed professionals are competent and do not pose a risk to the public. A professional licensing board is created by enabling legislation, which establishes a board's form, mission, powers, functions, tools of implementation, and enforcement ability. A board is considered to be a creature of statute, meaning a board's power is dependent upon its authorized statutes, and therefore any exercise of authority claimed by a board must come from those statutes, either explicitly or naturally implied. A board may administer, implement, and enforce only those statutes. If those statutes are silent on a particular action, the board lacks authority to take such an action. Simply put, a board can do only what the Kansas statutes say it can do. Besides statutes specific to the board, a board's authority is limited by constitutional equal protection and due process rights, which prohibit a board from acting in a way which result in disparate or inconsistent treatment of persons similarly situated, from adopting different standards for similar situations, or otherwise acting arbitrarily, capriciously, or vindictively. For example, a licensing board may not impose more severe discipline on male licensees solely because of their gender, or a licensing board may not revoke a license because the board does not like a particular person. Other constitutional guarantees, such as freedom of speech, rights of privacy, unreasonable search and seizure, and vagueness, also establish parameters on a board's authority. In terms of the legislative authority over the BSRB, the Kansas legislature retains control over certain aspects of the agency, such as 1, modifying the enabling legislation, which would change the purpose of the board. They could also limit the expenditures in an appropriations bill. The agency doesn't receive money from the state general fund, as you may recall. However, every year we submit a budget, and part of the reason for that is they establish how much we can spend on a year-to-year basis. So even if we had a lot more money in the agency's fee fund, they establish how much we are able to spend, and we cannot spend beyond that amount, even if we still have money in the fund. Legislative authority also over the BSRB could include enacting new legislation to change the makeup, scope, or powers of the board. And then in terms of the functions and duties of a licensing board, in order to carry out its purpose, the board is granted or delegated powers and functions that parallel the 3 branches of government: executive, judicial, and legislative. The executive authority, the board carries out its enabling act. It also follows the Kansas Open Meeting Act, or KOMA. We'll talk about that a little bit more. And it follows the Kansas Open Records Act, or KORA. In terms of the judicial authority, the agency has quasi-judicial hearings in reviewing facts when violations of laws has occurred, and also follows the Kansas Administrative Procedures Act when appropriate. We'll talk a little bit more about CAPA as well. In terms of the legislative authority or the administrative authority, the agency is able to adopt regulations to implement or interpret the enabling acts with more detailed or specific requirements. This process involves holding an open hearing on proposed regulations, allowing feedback, and there's oversight by a legislative committee. In order to fulfill its responsibility to protect the public from incompetent, unprofessional, and unauthorized practitioners, a regulatory board implements and enforces statutes and regulations, and at times operates according to internal policies. In order to be effective, board members need to understand the differences between statutes, regulations, and policies. First, for statutes, statutes are laws passed by the Kansas legislature through authority derived from the Kansas Constitution and subsequently signed by the governor. Statutes generally become effective on July 1st of that session year, but can become effective if a different date is specified in the legislation. Statutes set the parameters of the board's authority. Statutes control any inconsistent regulation or policy. If a board becomes dissatisfied with the scope of its authority, for example, the board determines that it needs investigative subpoena authority, the board must first seek legislation to obtain its goal. Concerning regulations, regulations, on the other hand, are adopted by a board to further implement or carry out the purpose of a particular statute. A board's authority to adopt regulations is derived from statute. In adopting rules and regulations, a board follows the Rules and Regulations Filing Act to ensure that the process of adopting regulations is open, receptive to public and legislative input. It addresses the economic impact of board and those affected. The regulations themselves are consistent in style, organization, and grammar, are lawful, and are filed and published. Regulations are also promulgated to complete or fill in details of a statutory scheme, such as implementing statutes, and affect rights or responsibilities of third parties outside of the board. When adopted in accordance with the Rules and Regulations Filing Act, regulations have the force and effect of law. They are legally enforceable. To be valid, a regulation must be within the statutory authority conferred upon the board, implement a specific statute, or otherwise pass the test for legality. Any regulation that goes beyond the authority granted violates the enabling statute or is inconsistent with the statutory power of the board. Another statute or the Constitution will be found void. Policies are the third layer, and policies may be adopted by a board only to guide its internal operations, such as prioritizing staff workload or explaining the investigative process. Guidance documents are documents that state a board's current approach to or interpretation of law, or general statements of policy that describe how and when the board will exercise discretionary functions. When you're looking at how to be an effective board member or an advisory committee member, there's a few basic items that I would point to. One, you can read the board's enabling statutes, and those are posted on the board's website. They begin with KSA 74-7501. You can also read the board's licensing acts, which are linked on the board's website. You can also read the regulations for each licensing act. If you go to our website, there is a drop down for statutes and regulations. Under statutes, it has the main statutes for the board, followed by a separate set of statutes for each of the professions. There's also one drop down that has regulations, and another broken out by the professions as well. And then I would also recommend reading the BSRB policies that are posted on the website. When you review those documents, be on the alert for agency policies and internal procedures which may be inconsistent with or conflict with the board statutes or regulations, or which affect requirements for applicants or licensees. And be willing to initiate action to amend statutes or modify regulations. So if you do review those documents and you have questions, please feel free to reach out to me. There may be an item that we need to correct, or there may be a reason that has to do with a term of art in terms of some of the language, and that would help kind of explain why language is a certain way, or if there are items for us to change, it would be helpful for us to be aware of that so we can expose those changes to the board. If a statute or regulation seems confusing or vague, it could appear that way to individuals who must comply with them. Remember, the purpose of imposing discipline against licensees is to encourage compliance with the law and protect the public. Discipline should not be vindictive or disproportionate to the severity of the violation. Always be mindful that the role of the board is to protect the public, not the licensees. Concerning the topic of conflict of interest. Conflict of interest typically means having any interest, financial or otherwise, direct or indirect, or engaging in any business or transaction or professional activity, or incurring any obligation of any nature, which is in substantial conflict with the proper discharge of the board member's duties in the public interest. Concerning board members and advisory committee members, they must make sure that they must make public and recuse themselves from any conflict of interest that exists to ensure the integrity of the board and all its decisions. Disclosure and recusal are important tools to avoid actual or perceived conflicts of interest, but board members must not overuse recusal as an excuse to avoid conflict and exercising their full responsibility. Personal conflicts are those types that may ultimately have a personal consequence that is a direct or indirect effect of a decision or action. No decisions should be made that will advance the personal benefit of the board member. Some example of personal conflicts are personal gain, bias, or the effect on a personal relationship. Concerning confidentiality, at all times, a board member or an advisory committee member must conform to the rules of confidentiality in dealing outside the boardroom. Protected information obtained in the capacity of board member must remain confidential during and after board membership. Termination of board membership does not dissolve the board member of responsibility. The rules that apply during active board membership continue to apply after termination of board membership. Confidentiality must be maintained on all confidential subjects that the individual is privy to as a board member. Some examples of times when confidential information could be discussed: executive sessions that occur during an open meeting where there would be a vote to go into executive session. Those members would exit and go into executive session. So any of those conversations after executive session had begun. And then also another example of when confidential information could be discussed would be deliberations after a hearing. And this would mostly appeal to board members instead of advisory committee meeting members, but the board meetings are under the Kansas Open Meeting Act, or COMA. And then those deliberations after a hearing would be under the Kansas Administrative Procedures Act. And that allows the board to deliberate in private in order to reach a decision in a particular case. Concerning professional activities, a board member may hold an office in a professional or trade association of the regulated profession, but may not lobby for or cast votes regarding a matter that would impact the professional association or the board member's office in that association. The board member may not use his or her position on the board to further the interest of the professional association or his or her office in that association. Board members may attend professional conferences and social events, but they must be mindful of open meeting rules and conflicts of interest. If a majority of board members are present, do not discuss the business or affairs of the board to avoid triggering a meeting under the COMA. Additionally, do not discuss matters related to a particular pending application or a disciplinary matter. A board member should not represent himself or herself as a spokesperson for the board unless authorized by the vote of the board to speak on the board's behalf. If a board member is asked to give the board's position on an issue and the board has not authorized that member to do so, the board member must decline to comment or make clear that any opinions expressed are those of him or herself alone and not of the board. A board member should not ask board staff or board counsel to provide legal advice or preferential treatment to any applicant or licensee. And we'll talk a little bit more about what would trigger some of the Kansas Open Meeting requirements. So now we're going to focus on the COMA, the Kansas Open Meeting Act. The Kansas Open Meeting Act under KSA 75-4317 allows the public to observe governmental entities making decisions. Meetings shall be open to the public because a representative government is dependent upon an informed electorate. Because the purpose of COMA is to benefit the public, it is interpreted liberally and exceptions are applied narrowly to carry out its purpose. The COMA applies to all legislative and administrative bodies and agencies of the state and other subordinate groups thereof, receiving or expending and supporting in whole or in part by public funds. The COMA does not define the term subordinate group, but if created by a covered entity or the group has become an extension of a covered entity, most likely the subordinate group is covered to, subject to the COMA. So advisory committees do fall under the COMA just like the board. The COMA does not apply to an otherwise covered entity when exercising a quasi-judicial function or conducting a proceeding or hearing under the CAPA, Kansas Administrative Procedures Act. COMA also does not apply to the judiciary, private organizations, or staff meetings of a covered entity. A meeting is defined as meeting these three requirements. First, any gathering or assembly, whether it's in person, through the use of a telephone, or any other medium of interactive communication. Two, by a majority of the members of the agency or public body subject to the act. Three, for the purpose of discussing the business or affairs of the public body or agency. So one of the questions that I probably get most frequently after the training is, am I allowed to reach out to a member of the advisory committee? Because members say, I don't want to accidentally violate one of the laws or rules on open meetings. And so it's really important for you to understand what would constitute a meeting that we would need to make public. First, it's okay to contact a member of the advisory committee because when you're looking at what would constitute a meeting, it would have to be a majority of the members of the committee. So as long as you're not involving the majority of members of the committee, then you would be fine. But two, you may say, well, we were at a social function and I saw a majority of members of the committee. Are we in violation? And I would say, no, you just have to be careful because the requirements of a meeting would say that you have to be there, essentially discussing the business or the affairs of the body. So if you're there together, but you're not discussing items relevant to your work on the advisory committee or the board, that's perfectly fine too. One thing to be cautious of though is we think about meetings in person, or now we look at them in terms of, by phone or by screen. It also could involve something like an email or a text communication too. So when you have those interactive communications, whether it's in person, by Zoom, by email, by text, those can constitute a meeting. So that is why we're not able to have discussions with the advisory committee back and forth by email outside of a meeting. On behalf of the agency, I can forward information to you. I can always provide information for you to review in advance of the meeting. If you have individual questions, feel free to contact me directly, but we have to avoid instances where we have any back and forth discussion with the members of the committee, because if that is interactive discussion with the majority of members, and we're talking about business related to the committee, those have to be as part of an open public meeting. Meetings may be conducted by telephone or other electronic medium if the board complies with all COMA requirements. A meeting includes informal discussions before or after the public meeting or during a recess of a public meeting, and all gatherings at all stages of the decision-making process. The name of the gathering is irrelevant, thus work session or retreat are subject to COMA. And if you recall, when I talked about the board's offsite meeting on October 23rd, I did mention specifically that even though it is offsite, it is open to the public. So it is going to be an in-person meeting, but any individuals from the public could attend that meeting on October 23rd. A discussion does not require binding action or voting. A discussion can occur at social gatherings, retreats, and meetings held in private, educational conferences, or seminars. Thus, when traveling to such meetings, members of the board should avoid discussing business or affairs of the agency. A presiding officer has the duty to provide notice of the meeting, but this duty may be delegated, and we take care of all the public notice for meetings on behalf of the different boards and committees. The COMA does not require notice of meetings to be published in a paper or on a website. An individual must request notice of meetings. There can be no formalities. To requesting notice, it can be verbal or written. And so we do have a list of people who requested notice of public meetings. We send out an email when those meetings are scheduled. We also post information on the BSRB website. And we also use a website called the Kansas Public Square. It's a way for state agencies and other entities to post notice of upcoming meetings. And so we go ahead and post all that information and make it available about meetings. The notice must provide date, time, and location where a body will meet to the person requesting notice in a reasonable time before the meeting. A request is valid for 1 fiscal year. The board must notify a requester of expiration before terminating notice to that requester. The COMA does not address meeting procedures. A board is not required to follow Robert's Rules of Order or any other similar formal rules of procedure. And this is why we can take votes on different items, or we can look at consensus for reaching agreement. But the BSRB and state agencies in general, they're not required to follow specific procedures unless you decide that you're going to adopt those and follow those. The COMA does not require a board to create an agenda, but if one exists, it must be made available to everyone. A person may record a meeting if doing so is not disruptive, and the public does not have the right to speak, but only to listen and observe. The board cannot vote by secret ballot. A board policy may require minutes to be kept, but the COMA does not require the board to have minutes unless there is a motion to go into executive session. The motion as made must be included in the minutes. An executive session that permits discussion of certain enumerated matters outside of public view. To take an executive session, the board must first convene an open meeting. The board cannot take binding action in an executive session, but a consensus is allowed. If a consensus is achieved, the board must reconvene the open meeting and take a formal vote in an open session. So in terms of any violations under the COMA, prosecutions under COMA are civil, not criminal. Any person, county or district attorney, or the attorney general may bring an action in district court. The county, district attorney, and attorney general have subpoena power, enforcement actions, and other precedents over all other cases, and are assigned for trial at the earliest practicable date. The remedies for a COMA violation include voiding any action taken if prosecuted by the attorney general or county district attorney only, an injunction stopping an action a mandamus forcing an action, or a declaratory judgment. The penalties for a coma violation include a fine up to $500 per board member, not the board, for each violation. Ouster from office, recall from office, court costs assessed to the person seeking enforcement of coma, court costs assessed against the plaintiff if maintained action frivolously, not in good faith, or without reasonable basis in fact or law. And so before I move to the CORA, the coma is something we do take very seriously. I was familiar with a lot of those different items before I became a member of the executive director for the BSRB. I worked for the state legislature of Kansas and the legislative research department for about 8 years. And so I was used to staffing committees and providing notice. And so working on behalf of the board and the advisory committees, we do take extra efforts to make sure that we put out notice of meetings in advance. If you ever have questions about any of those different items, or you think we may have forgotten to post something, feel free to contact us, but we try to be very diligent about making sure that information is posted and that we're following all the guidelines and the requirements for open meetings. In terms of the next item, that has to do with the Kansas Open Records Act, or CORA. So the Kansas Open Records Act requires the board to have its records open for inspection by any person unless otherwise provided, and CORA shall be liberally construed and applied to promote such policy. A public agency includes the state or any political or taxing subdivision of the state, or any office, officer, agency, or instrumentality thereof, or any other entity receiving, expending, or supported in whole or in part by public funds appropriated by the state or political taxing subdivision. The term instrumentality is not defined in CORA. Nevertheless, if created by a covered entity or the group has become an extension of a covered entity, it will most likely be covered. A public agency does not include private companies, even if they receive public funds in exchange for goods and services. Judges and courts, an individual legislator or a member of a governing body, private individuals, or state employees. A public record includes any recorded information, regardless of form or characteristics, which is made, maintained, or kept by, or is in the possession of any public agency and written records, photographs, computer data, and email. A public record does not include records that are owned by a private person or entity and are not related to functions, activities, programs, or operations funded by public funds, or records not in existence at the time of the request. A board is not required to create a record in order to fulfill a request. Under CORA, the board must appoint a Freedom of Information officer to assist with CORA requests. And for the BSRB, that's our Assistant Director, Leslie Allen. We must explain, distribute, or otherwise make available a brochure describing requester rights, agency responsibilities, and procedures for inspecting or obtaining copies of public records. We do have this document posted on our website. It's a open records request form, and it also describes the process by doing so. We also have this available when you walk into our physical office. It's one of the first documents that you can see. It's posted right by the member of our clerical staff, and it's posted there so any individuals can walk in and see a copy of it. And then also we're required to include the name and title of the record's custodian, fees, and hours available for anyone to make a request. And that's also in that document that I described. In Kansas, any person may make a request. The person need not be a resident or provide a reason for their request. The board may require the request to be in writing, state the name and address of the requester, provide proof of identification, and sign a written verification that the requester will not use names and addresses obtained from the records to solicit sales or services. Unless closed by law, the board cannot deny a person the right to review its public records. For instance, copyrighted material may not be reproduced without the permission from the copyright holder, but must be available for viewing or listening. If portions of a record are closed, the remainder of the record must be made available to the requester, which is referred to as redaction. The board is not required to make copies of a recorded tape or disc, videotape or films, pictures, slides, graphics, illustrations, unless those were shown at a public meeting. And the request must be acted upon as soon as possible, but not later than the end of the third business day following the date the request was received by the board. And then 3 responses are acceptable from the agency. 1, the request is provided and the form requested if possible. 2, the request is under review and the records are permitted, if permitted, will follow. Or 3, the request is denied with an explanation, detailed explanation for the denial. And one notable thing on this, with a small agency, we have a number of other responsibilities, and sometimes individuals are, on vacation, or I'm at the Capitol for meetings. And so our responsibility by law is to respond to these within 3 days. That doesn't mean that we need to have done all of our research and provide all the documentation in 3 days. It means that we need to send a response, noting that we have received it, and then we have to either provide the records at that time, give a denial and explain why we can't provide those records, or we have to let them know we're reviewing our records, we will research this topic and provide those records when we are able to do so. Under the KORA, there's a presumption of openness. As such, the requested public records must be released unless an exemption to disclosure applies. The burden rests on the board to prove the requested records are exempt from disclosure. Exemptions to disclosure may be discretionary or mandatory. The COMA is a civil act, not a criminal act. So any person, a county or district attorney or attorney general would bring a civil prosecution. And then similar to what I explained under the COMA, that's how this would operate if an individual brings a complaint under the KORA. Additionally, in actions brought by the county district attorney, fines are up to $500 per violation. They may be imposed for a knowing violation or an intentional failure to furnish information. Costs and reasonable attorney fees, including appeals, may be imposed if the board's denial is not made in good faith or without a reasonable basis in law or in fact. So that is the KORA. And then before we move to the CAPA, one thing I will say about the open records is you are all professionals, and I'm sure you've had similar trainings in the past. You are, I'm sure, well aware that a record is not always something that would easily be identifiable as a very public document. You know, a record could be an email communication, or it could be something that, you know, is just a, you know, kind of a write-up that you have to document what occurred. And so sometimes these records, what I want to stress is to make sure that you're keeping in mind your responsibility and your position as an advisory committee member. And so when you're communicating back and forth, just keep in mind that even though the topic in general may not be the most formal, any of those could be potentially requested. And then if those documents are requested and we have to turn those over, those are all things that could appear, let's say, in the newspaper, or could appear in one format or another. There was a recent article in the Topeka Capital Journal, and someone had made an open records request for Teams communication. And so there was a transcript of Teams dialogue between two employees. And so I think there are some examples of records that people may not always consider to be a record, but just make sure that you're staying professional in those communications and everything should be fine. And also what I would say too is we try to do our best to make sure to help you with any of these types of these items. And so if you do get an open records request for anything associated with your membership on the board or on the advisory committee, please let us know. And it's always a good idea too, when you're talking about board business, if you want to copy me on there on behalf of the agency, if we have a copy of the records, we can always provide it. If we don't have a copy of the records, it could make advisory committee members subject to the KORA, and then you would have to search your records for anything that would then be in response to one of these types of requests. So if you do have questions about open records requests, go ahead and let us know. We handle most of these on behalf of the agency, and we do get assistance from legal counsel with anything that's a question about that. Now we're going to move briefly to the Kansas Administrative Procedures Act. It creates only procedural rights and imposes only procedural duties. The CAPA does not provide substantive law. Those laws are governed by the board's Enabling Act and Licensing Acts. The CAPA applies only to the extent that other statutes expressly provide that the provisions of the CAPA govern those provisions. The general rule is that licensing agencies or licensing boards like the BSRB must do business in an open meeting under the COMA unless directed by statute to conduct the proceedings or hearings pursuant to the CAPA. Those two acts are mutually exclusive. So when a licensing board statutes provide that the CAPA applies to certain decisions, the board shall follow CAPA, not the COMA. But when making those decisions, the CAPA sets out a procedure to follow when the board is deciding what to do in cases involving individual licensees, much like the procedure that is followed in court cases. So for example, when we're talking about the way the board is going to look at a class of licensees in a specific area, or all licensees, that is something that would be in a public meeting under the COMA. When we're looking at the requirements for licensure for a specific person, an individual licensee, that information is pretty confidential, and so the board considers those under a closed session under the CAPA. In certain cases, the board is conducting a quasi-judicial function in deciding the outcome of a case. When the CAPA applies, none of the stages of a particular case has to be open to public observation other than a hearing. Each of the board's licensing acts has a CAPA provision. Under the CAPA, neither the public nor the applicant has to be notified when the board meets to consider an application for licensure. Similarly, under the CAPA, Neither the public nor the licensee has to be notified when the complaint review committee meets to consider possible or whether probable cause exists in a discipline case or issue a summary proceeding order. Additionally, the board and the CRC do not need to take a vote in public for decisions made under the CAPA. Under the CAPA, decisions are made when the license or an order is issued. When necessary, board staff and the board or CRC's attorney can be present during the CAPA discussion to make sure that board members have the information or legal advice they need to make an informed decision. There are some board activities that are not covered by CAPA, and these must be acted on in an open meeting under the COMA. These include approving board minutes, discussions and votes to approve or amend regulations or guidance documents, delegating authority to a board member or to the executive director for particular actions, receiving agency updates regarding the budget, legislation, statistics on complaints or CRC activity, education and the executive director's report, decisions on whether to renew contracts or change the way contracted services are provided, and policy decisions affecting the way the board operates internally. And concerning applications for licensure, a person who files an application for licensure has the burden of proof. Staff will gather the information submitted by an applicant for the board's consideration in determining whether the applicant is qualified for licensure or whether a license may be conditioned or restricted. If the board denies conditions or restricts a license, an applicant may request a hearing if the applicant did not agree to such action in a consent agreement in order. Concerning investigation, the board has the burden of proof to show a licensee has violated a statute or regulation. All licensing boards can investigate complaints or allegations that a licensee has violated its statutes or regulations, and the board's investigator generally gathers information and then presents that information to the CRC. The CRC reviews the information and determines whether there is a probable cause or reasonable grounds to believe the licensee has violated the statutes or regulations. Reasonable grounds means information that would lead a reasonable, prudent person to believe the licensee violated one of the board statutes or regulations. When making the determination, the CRC must make sure the conduct the licensee is accused of actually violates one of the board statutes or regulations. The fact that the licensee did something that made someone angry, violated a professional association's ethical code, or did not follow an employer's policy does not necessarily mean that licensee violated a statute or regulation. The licensee can request a hearing on a summary proceeding order within a certain prescribed period of time. Once a petition or a request for hearing is filed, the CAPA guides the proceedings and the hearing. If there's an immediate danger to the public, health, safety, and welfare, the CRC may suspend a license without giving the licensee notice and an opportunity for a hearing. A licensee may appeal an emergency order to the district court. And then the last item I'll cover before I'll end the training has to do with the Kansas Tort Claims Act. So the Kansas Tort Claims Act generally governs the liability of state of Kansas employees and its agencies and employees. An employee includes a member of a board or committee of a governmental entity, including elected or appointed officials and persons acting on behalf or in service of a governmental entity in any official capacity, whether with or without compensation. The basic rule of the Kansas Tort Claims Act is vicarious liability for any actionable wrongful act or omission of government employees within the scope or course of their employment, subject to affirmative grants of immunity that may exist on a case-by-case basis. If you are sued for an act that occurred within the scope of your duties as a board member or advisory committee member, you are entitled to have the state defend you at no cost. To obtain representation by the state, you must submit a written request in 15 days after service of process, and then you must cooperate in your defense. And then the state may choose not to defend you if you acted in an actual fraud or malice and failed to make a timely request for the representation. The general rule is that the state will pay for any judgment rendered against you unless the judgment is for an act or omission that occurred outside the scope of your duties as a board member or advisory committee member, you failed to cooperate in your defense, or you acted with actual fraud or malice. And so I hope that never comes up, but I think it's important for you to know there was a Attorney General's opinion that was issued a few years ago, and that is linked on our website as well, whether advisory committee members would fall under the Tort Claims Act. And it was a finding that yes, they would fall under that group of people protected by that act. And so, like I said, I hope it never comes up. It has not come up since I've been with the agency, but I wanted to make you aware of it. So if you ever are informed by someone they are starting litigation against you because of something you did as a member of the board or as an advisory committee member, please make us aware at the earliest possible time. That way we can make sure to let our legal counsel know about it, and then also request some representation from the Attorney General's office as well. So I realize I covered a lot of information. This document is available for you to review on the BSRB website. At this point, I will stop sharing my screen and I'll see if there's any questions. Like I mentioned, the topics that tend to come up the most after the training has to do with, board members or advisory committee members wanting to make sure they don't accidentally violate the Kansas Open Meeting Act. And the big takeaway from that is just to make sure you don't email or call a majority of members of the committee unless we're in a public meeting. And you can always ask me questions. You can ask me to forward information out to the members of the committee. So if we do talk about something at a meeting and you say, oh, well, I have something relevant to that, can I just send that out to everybody? It is probably okay for you to send it out to everybody, but the safer way to do it would be to send it to me, and then I can distribute it on behalf of the agency. And then if anybody from the public wanted to request a copy of that, since the members of the committee have that, it would be available for individuals from the public to obtain as well. And then anything in terms of public notice, we will take care of all of those items for the committee. But if you think that there might be an issue with that, please bring it to our attention. We're happy to make any corrections or kind of explain why something looks a certain way. We do that introductory information at the very beginning of the meeting. And part of that is just to make sure that we're providing notice about different procedures and where people can find information. So we're really trying to be proactive and making sure members of the public can participate. And then in terms of those records, like I mentioned before, documents that we provide to you on behalf of the BSRB, those are records that would be considered under the Kansas Open Records Act, potentially for their use. Some of those potentially at times could need to be redacted, depending upon which records they're being used for. But also just keep in mind that when you're communicating back and forth, even if it's an email that you're getting close to a holiday and you send something, just make sure that you're staying professional, because any of those records could be potentially requested. And you always want to make sure that anything that could be made public always reflects yourself and everything else in the best possible light. So like I said, with that, I will end my presentation and see if there's any questions. And this is not a one-time opportunity. So if you do walk away and, tomorrow you start thinking about things a little bit more and you want to reach out to me with questions, feel free.
The next item on the agenda is revisiting old business, and we are now kind of getting short on time. I would again ask for David's guidance on what is the best course of action with the time we have left.
Sure. So I think some of these items we can talk about at this meeting or the following meeting in October. So I can start to frame this item, and then if there's any items that we need to carry forward, they can just stay on the agenda, and then we can talk about the next meeting.
Okay, that'd be great.
Okay. Well, the next item on the agenda under old business is continued discussion on proposed changes to unprofessional conduct regulations from other professions. And so you may recall last year, each of the different advisory committees was asked to review the unprofessional conduct regulations for their profession. There are 7 professions, and each profession has a separate unprofessional conduct regulation. And so each of the advisory committees worked through the language in their regulation and submitted proposed changes back to the board for modifications to their unprofessional conduct regulation. The board collected all of those and wanted to distribute out that packet of the combined proposed changes for all the professions back to the advisory committees. So that way you could review the packet and see if there were changes that maybe another advisory committee had discussed or recommendations that maybe you thought looked good to bring over to your profession. And so that's what time has been allowed on the agenda today, is that if you saw something from another profession that you thought would be helpful to bring over to the list of proposed changes for the addiction counseling, now would be the time to kind of reference those. And so we could make a note to bring those and incorporate those into the proposed changes. And the goal is for, to be able to forward final proposed changes to the board. The board can consider these at the end of this calendar year. So I think being able to talk about them at this meeting, or if you still want a little bit more additional time, you would be able to discuss those at the next meeting in October as well. And then probably that would be the last opportunity before they're forwarded to the board to go ahead and have a lengthier discussion on at the board level.
This is Dulcinea, and I don't have anything at this time, but yeah, maybe we revisit it at the October meeting just to be sure.
This is Mike James. I agree. I don't know that I have anything in particular, but I might want to take another gander at some of those to see if there's something that stuck out to me that I missed.
And I agree. And David, I'm wondering were those sent out with today's agenda? Was that, where would we find those?
I believe they were.
Okay.
Yeah, I think there was a
Oh,
about 40 pages, I believe. I will double check if they were included. If they
maybe
were,
I'm just not seeing them. I'm seeing other people shake their heads, so I'm thinking maybe it was.
okay. Yeah, they should be labeled as item 7A.
Yeah. I
Okay.
think it was the 6th attachment,
Okay.
Christina.
Perfect. Thank you so much. But yeah, I would agree. Maybe a little more time to talk about it since we only have like 15 minutes today.
Okay, we can plan to have a more discussion on the next meeting. But yeah, take a look. Each of the advisory committees approached them in a little bit of a different way. One of the advisory committees had a subcommittee specifically for reviewing those. And so while we do strive for consistencies between the professions, we also know that there's kind of a balance. For some of those professions, they have a national association, and sometimes they provide direction in terms of unprofessional conduct. And so sometimes there's an inclination to want to match what their national association is providing, but also there's the effort to try to make things somewhat uniform between the professions we regulate. So finding that balance is a little tricky sometimes. And so, Jill, I think if they're going to review this more at the next meeting, maybe we could move to the next item for old business.
Absolutely.
Okay. Then the next item under 7B is continued discussion on possible changes to clinical training plans. And in your packet of material for today, you have a copy of a regulation. It is 102-7-6, professional postgraduate supervised experience required for clinical addiction counselors. And just to kind of frame this topic, at a recent board meeting, it was discussed that there is a requirement in regulation that you must have an approved clinical training plan when you're accruing hours towards a clinical license. And there is a requirement for this profession, it's item J in this regulation. And so I've highlighted it in the copy that you received. And it says all changes to the clinical supervision training plan shall be submitted to the license by the supervisee to the board for its approval. The changes shall be submitted no more than 45 days after the date on which the change took effect. And if the supervisee fails to submit the changes to the board within that 45-day period, no supervised hours of practice shall be accrued or credited for any practice beginning on the day the changes took effect through the date on which the changes to the plan are approved by the board. And so the board recently talked about that and said there is a desire to make sure that people are doing items that are consistent with an approved training plan, or to make sure that we have the ability to review changes to make sure they still fit. But that requirement that if they don't submit within 45 days, that they would lose all those hours is a pretty steep consequence. And in talking with some other states and jurisdictions, it sounds like we're a bit unusual in having something along those lines, but there's also a lack of consistency in terms of regulations on supervision. So the board had asked advisory committees to really think through that regulation to see if there's an alternate way to kind of approach that topic with still achieving the desired outcome, but maybe provide more flexibility for the board to be able to evaluate other situations. And so if you look in your minutes under item 6A, there was a discussion at the last meeting. And what the advisory committee talked about at that time was the advisory committee was supportive of changing it from reporting all changes to making it reporting substantial changes, which would include but may not limited to, and then listing specific categories that would need to be reported. such as setting types of clients and changes in supervisors. They were also supportive of providing forms to applicants when they submit their plans, which would give instructions for providing changes to those plans, and then allowing some flexible language for the board to be able to review changes rather than have a strict requirement that those would all be denied. And then further, there was a recent change to lower the number of hours from 4,000 to 3,000. And at the time, there was a requirement that the hours can be completed in no fewer than 2 years. But with that change from 4,000 to 3,000, there was no change in the amount of time to complete those hours. And so at the last meeting, the advisory committee was supportive of forwarding to the board a recommendation to say the hours, since they're moving from 4,000 to 3,000, that could be completed in no fewer than 18 months, which would maintain the same ratio that the 4,000 hours tied to. And so those were the recommendations from the last meeting. And if those are still your recommendations, we'll go ahead and forward those. But I wanted to give you another opportunity if you had additional thoughts to make other changes to the recommendations for your advisory committee.
I don't know how this could be stated, but it feels like no matter what we come up with the parameters in terms of number of days that we require it or what we're requiring, there's always going to be a legitimate exception to that. And I don't know if we can write that in a way that acknowledges that. That's just like my initial reaction, because I haven't looked at that in a while. That's what I'm thinking right now. I wonder what others might think.
Well, and part of this kind of goes to the current language says, if you don't submit the change within that time period, those hours shall not count. And I think there was an interest in making it that the hours may not count to allow the board the opportunity to review those cases. And so the board would be able to kind of still have the opportunity for review. Right now, the board can review it, but with that language, the board is held to a really strict standard. And so the only real flexibility the board has is to determine if something actually is a change. And so in a lot of cases, the board has to reject those hours. So that may address one of the concerns that you referenced, or there may be another way to approach that.
So currently it could be worded with the use of the word may reject the hours.
Yeah, I think that's one of the things that has been discussed.
Okay, well, I think that allows for the flexibility.
And there's pros and cons with this. You know, we've had some discussions that right now, from a licensing perspective, we have a clear standard where we can tell people if they have questions, and we can say, right now it says all changes have to be reported. And it would make things a little bit murkier in terms of us providing guidance to people. But I think there has been some interest by the board to make sure that if we can provide more flexibility to be able to review those hours. I mean, ultimately, we don't want people to be spending time accruing hours that would not count towards something that would fall under approved training plan. But if it's something that's being denied because of a technical reason of failure to report within 45 days, if there's a better way to approach this, I think that's something the board is really looking at to try to be more considerate to the applicant. Well, and if I'm not hearing any other comments on this, then I'll just go ahead and summarize that item and then have that ready to be forwarded back to the board at the next board meeting. Okay, and then on the agenda, the next item was also following up on a discussion that happened at the last meeting. Basically, the advisory committee had been asked to look at two different regulations, one that involves continuing education, KAR 102-3-10A, and then also a regulation that was more or less a companion regulation, KAR 102-3-11A, which was documentation for continuing education. And so the first regulation deals with what qualifies as continuing education and a few that don't. And then the second regulation is really more focused on what would you need to produce if you were audited to demonstrate that you had completed those hours. And so at the last meeting, under 102-7 under the, looks like there might be a little typo in the minutes here, but I'll make sure, if it's okay with you, I'll go ahead and ensure that the numbers for the regulations for continuing education matches what we have for the continuing education regulation and also the documentation of continuing education. But last meeting, there was a discussion about whether or not, right now the regulations say that if there is no post-test, there's a limit to how many hours can count for continuing education. And advisory committees discussed whether they would like that to stay in the regulation, but there was no formal recommendation to change that. So if you would like to change that so that all hours could count for that, that would be something that we would need some direction on. And then also there was direction from the advisory committee last time to remove language which allowed self-directed learning projects. And I think some of the rationale for that is because we rarely receive any kind of submissions for that. And those types of projects are already probably covered under another category that you would be able to accrue hours under. And so those were the two that I had for that regulation. And then for the documentation of continuing education, there was language that said that copies would not be accepted, and the advisory committee was in favor of striking that because in this digital age, we receive copies of things frequently, and that should be sufficient. And then there was a note to go ahead and discuss that further. So I guess wanted to see, would you like to officially make a recommendation to allow hours for if there is no post-test to be able to count all the hours in that category? Or do you have additional thoughts on that item? Or do you have any general thoughts that maybe we did not have a recommendation on last time for either of these regulations?
I would be okay with making the recommendation for allowing all the hours, even if there is not a post-test.
This is Jason. I would agree with that. I mean, there's a lot of, I've been to quite a number of CEUs over the years that wasn't a part of the deal. And you don't know that going in. And so it seems like if we keep it this way, you could be looking at a crapshoot, especially as things continue to go online. And sometimes those post-tests don't work very well. And so do you just get hammered because technology didn't work for you? I have rarely seen the benefit to the post-test in all of my years of doing this work.
And just for context, this would address item number D5, which currently says if a post-test is not provided, an activity consisting of completing a computerized interactive learning module, viewing a telecast or videotape, listening to an audio tape, or reading, the maximum number of allowable continuing education hours shall be 5. And so the one above it said if there is a post-test, you can get all of your hours that way. So.
Does anybody know of any evidence that suggests that people learn any better or that there's more retention or any like the benefit of having a post-test versus not a post-test?
That's a really good question. I'm thinking about my own experiences, right? When I take them and when I do the post-test, because of the length of time and in that time frame that I'm doing that work, if I can't retain it based on that session, I don't know that I would. Or if I didn't go back and read it later, you know what I'm saying? Like it's in that moment of doing that, however long it's taking me to do it, it's in such a short amount of time. I feel like I'm either going to retain it all or none of it. And for the post-test to really be good, I'd have to go back and revisit it several more times, just like I was studying for a test. I don't know if I'm making sense.
So I don't know if there's any particular data to point to those post tests. I think the only component that they likely do is ensure that, if it's a videoed one or kind of that kind of piece, that it's not that somebody turns it on,
Yeah,
does all kinds of other
I-
work, and then,
I think that's the purpose.
I think that's the only thing that I can see of that piece. And I know, but I also there are times where it's like, okay, that's not that useful and it doesn't really check it. Yeah.
I think
agree.
it gets back to, oh, sorry, go ahead, Jill.
I agree with Mike that it seems the purpose seems to be to verify attendance, not necessarily retention. And my experience of post tests is you can take them as many times until you pass it. So if you're just gonna take it repeatedly, that's not the point of a test.
Yeah, and I think total agreement with what everyone is saying. It does seem like even if you do have a requirement that the person is watching, like you just said, Michael, you can play it and go walk off and still take the test and keep taking it until you pass it. So I don't know that it really ensures. And just like I think we talked about last time too, that if someone's at an in-person training, you can't guarantee they're paying attention or not, doing something else either. There's no post test for that. So I think, it's, to me, it always falls back to kind of your ethical, kind of your own, learning. And this is part of the profession, and you're hopefully taking trainings that are helping you and therefore are internally motivated to, retain or to pay attention or to make some effort for learning. So I guess I wonder, how much it's helping or.
So yeah.
Well, and I think post tests are an interesting breed, and Jill, that was a good point. Oftentimes you get to take them 10, 12, 15 times. Other times the post test is something that, quite frankly, you would find ridiculous anyway, but they call it a post test because you have to have written down a word at the beginning of the thing, and now you have to remember the word at the end of the thing, and they call it a test. And it's just, how do you judge what a test is in this particular scenario? Because I've sat in on some in years that I think, okay, that's what this is. and I met the criteria, but that's all it did, was meet a criteria. And it wasn't necessarily a judge of knowledge of the content. It was more a judge of the knowledge that, hey, you paid attention and stayed through the whole thing. I don't know. I don't see a reason to limit it.
This is a really good discussion. We're right up against time. So I think we'll probably have to continue this to the next meeting. But something to think about for the next meeting, 4 and 5 do provide several different types of activities, including computer interactive learning module, viewing a telecast or video, listening to an audio, or reading. And I'm curious your thoughts next meeting, if those would all be considered the same, if you'd be okay with someone reading for that length of time if there was no post test. And then also potentially we would want to make some cosmetic changes to the regulations. There is some language here that references things like videotapes and audio tapes, and much more commonly we would have video recordings and audio recordings. So some of that updating of language I don't think would rule anything out that people are currently using, but it would probably be more updated for the time we're living in today. So but I think we can revisit this and have further discussion at the next meeting.
David, do we need to set the date for the next meeting?
We can do that, or I can send out a poll. This is a group that had been meeting on Fridays, and I know that maybe some schedules had changed with membership changing on the committee. So how about if I just go ahead and send out a poll? I'll send an email, and then that'll have some different options for meeting times. So just go ahead and use that to note when you're available for the next meeting, and then I will find the date that has the fewest conflicts and go ahead and send out a notification with a calendar invitation for you.
Okay. That seems to bring us to adjournment, and from the previous minutes, it looks like I would ask for a motion to adjourn the meeting.
I'll motion to adjourn the meeting.
I'd ask verbally if there's any opposition to adjourning the meeting.
No.
Nope. Okay, the meeting is adjourned.
Thank you all for your time.
Thank you all.